Welcome to Navigating the FTC's proposed rule banning non-competes. We hope that this short video will give you some valuable information about the recent seismic movements at the FTC regarding a proposed rule banning non-compete agreements in employment contracts. I'm Laura Windsor. I'm chair of the Williams-Mullen Labor, Employment, and Immigration section. I'm here in the Richmond, Virginia office. And today I'm joined by my colleague, Jim Burns. He's chair of the Williams-Mullen Antitrust and Trade Regulation Practice Group. He's located in Tysons, Virginia. So we're going to be discussing today the new proposed regulations, the potential impacts to employers, and what you can do now to potentially get ready for whatever comes next. So just a little bit of background before we get started. As I think all of you know, on January 5th, 2023, the Federal Trade Commission, the FTC, issued a proposed rule on non-competes in employment contracts and stated that if the rule is finalized, it would prohibit most, if not all, such non-compete agreements in the employment context. So Jim, let's just start from the beginning. Was this proposed rule a surprise to you?
Well, Laura, it really wasn't a surprise. Exactly how they did it was a bit of a surprise, but we had been building up to something like this for several years. Back in the summer of 2021, President Biden issued an executive order where he expressly directed both the FTC and the DOJ Antitrust Division to focus some attention on non-competes in employment and what impact they were having on the American public. And after that direction from President Biden, the FTC and the DOJ Antitrust Division held some workshops and hearings at the end of 2021, and they jumped into this in 2022 pretty aggressively. So what we saw early in 2022 were some actual criminal actions being brought by the DOJ Antitrust Division in this space. And as you mentioned, in January of this year, the FTC proposed a rule that would ban non-competes. And prior to issuing that rule, literally the day before that, they announced that they had taken enforcement action against two companies for using non-competes in a way that the FTC deemed to be unfair and harmful to consumers.
Wow. All right, well, let's start with the rule. So obviously it's probably going to change, and we'll talk about that in a second, but what would the rule as it's currently proposed actually do?
Well, as the rule is currently proposed, it is very, very broad. It would literally bar any non-compete agreement in employment, with a very small exception, which would be in the sale of a business. Owners, 25% or more owners could be barred from competing for a period of time. But that would be the only exception. And that is a much more, a much broader restriction than we see in any state in the United States right now. Currently, there is a mix of state laws on non-competes, with the most restrictive being in California and North Dakota and Oklahoma, which ban almost all non-competes, not quite as many as the FTC would ban, but we have 47 states that really permit non-competes in at least some types of circumstances, and this new FTC proposed rule would ban them. So we would see a very significant change in the law in this area if this rule was enacted.
Well, so Jim, why does the FTC, a federal agency, think that we need this nationwide rule?
Well, that's interesting. The proposed rule, the announcement of the proposed rule indicates that 1 in 5 American workers is subject to a non-compete. And the proposed rule also indicates that if this rule was enacted, they believe that it could ultimately result in almost $300 billion in added benefit to American workers. So this is clearly a very significant issue, as President Biden noted in his executive order. And it's one that the federal regulators at this point really feel requires a federal response. I would analogize it a little bit to what went on with respect to trade secret law about 5 or 6 years ago, where trade secret law was governed solely by state law. And then in 2016, under President Obama, the Defend Trade Secret Act was passed, which provided a federal template for looking at trade secret law. This, in terms of a rule, would in large measure do something very similar.
Interesting. So you mentioned that normally non-compete agreements are dealt with at the state level. Is there any precedent at the federal level for challenging non-competes?
Well, there isn't much precedent in enforcement actions up until the day before the announcement of the rule. As I mentioned, the FTC announced 2 enforcement actions regarding non-competes. But there has been a period of years, for the last 10 years or so, there has been an increased emphasis and focus on challenging no-poach agreements, which are quite similar to non-competes. In a no-poach agreement, that's an agreement between 2 companies not to hire away one another's employees, where a non-compete is an agreement between the employee and the employer not to go work for that alternative employer. So both of them really focus on potential restrictions on employee mobility. And the non-poach has been an issue of significant interest, particularly to the DOJ Antitrust Division, all the way back to 2010 when they brought an action against several Silicon Valley entities. And I think it's important to note the no-poach area has become the focus of criminal actions by DOJ Antitrust, particularly in 2022. Back in 2010, those were civil actions. DOJ, in part in response to President Biden's executive order, has brought criminal no-poach actions in 2022.
Wow. So you mentioned that there were a couple of FTC cases that were announced right before this proposed rule came out. And frankly, it's the first time I've ever heard of the FTC bringing a case like this. But can you tell us briefly what those 2 cases were about?
Sure. I think that the FTC found 2 examples that they think really demonstrate what they characterize as unfair competition. In one, a security company had non-compete agreements with all of its employees that banned them from taking another job within 100 miles of where they were working. And if, in fact, you took one of those jobs, you could be penalized $100,000. And notably, because of a Supreme Court action 2 years ago involving FTC authority, in that case, the Supreme Court said that the FTC didn't have the ability to get damages in that particular case, but that they would in a rule. So I think we see, to your earlier question about why a rule and why now, I think it's the FTC trying to create the right recipe for seeking damages, seeking penalties, I should say, for improper conduct. The second matter was equally egregious. It involved glass companies, and they were barring their employees from taking any job in not only the United States, but also in Canada and Mexico. So I think the FTC smartly announced those actions the day before in order to demonstrate that there was a need for a rule. As you would imagine, the FTC typically doesn't create rules without being able to show a pattern of improper conduct that justifies a rule. So I don't think they would have issued a rule had they not at least first announced those 2 actions the day before.
Interesting. And of course, the FTC is it's the agency responsible for governing kind of those unlawful restraints of trade. So that makes sense that they would try to stretch their legs a little bit. But you'd said that normally these kinds of non-compete issues come about under state law. And I know just sitting here in Virginia, we've obviously had a lot of developments at the state level on non-competes. What other activities are you seeing at the state level?
Yeah, there has been a lot of activity at the state level in many states. I would say over 10, maybe a dozen in the last several years. there has been a push to ban non-competes, particularly with respect to lower wage employees, although not all of the laws that have been proposed or enacted focused only on that segment. For example, Hawaii passed a law a few years ago that said non-competes would not be permitted with respect to high-tech employees in their state. Virginia and DC both proposed and enacted laws that limited the use of non-competes for lower wage folks. There are other proposals in other states that would ban them for physicians, for example. So there is a hodgepodge all across the United States currently. And of course, the oldest and most well-known bar on non-competes is the one that California has, which has been in effect for over 100 years. So we currently have different laws in different states, and even the courts and how they administer and handle non-compete litigation, it varies state to state. So this is an attempt at the federal level to try to harmonize to some extent the protections that some states have already afforded to employees.
So if the FTC rule passed as it stands, which I'll talk about in a second, it probably won't, what would happen to those state laws that you just mentioned?
Right. Well, any state law that provides greater protection than the rule would still be in place. But any state that doesn't provide the protections of the rule, and as we talked about earlier, the rule is really very broad in terms of banning non-competes, those laws would no longer be in effect. The case law that supported those laws would no longer be in effect, and employees would not be subject to those non-competes. And not only would this be prospective, but this rule says if you're subject to a non-compete right now as an employee, it would be rendered void.
Wow. Okay. All right, Jim. Well, a lot of people want to know. So what happens next? So we've got this proposed rule that was issued on January the 5th. Where do we go from here? What happens?
Well, what happens next is a lot of reading at the FTC. The comment period started January 5th. It's been extended currently to March 20th. The FTC reports that they've already now received over 9,000 comments on this rule.
That is a lot of reading.
Right. So we got to give them a little bit of time to read all of the comments. But then I would anticipate that we will probably get an announced proposed rule sometime in the summer or late summer. At that point, though, because some of the comments and some of the public comments have been hostile to this rule, or at least to some aspects of it, including, for example, the Chamber of Commerce, the U.S. Chamber of Commerce has indicated that they don't believe this rule is appropriate. We are likely to see a legal challenge. So there will probably be a significant delay before any rule is implemented, unless they really change the text from what they currently have proposed in really material ways. And in any event, even in the current proposed rule, it indicates that it wouldn't go into effect until 180 days after the rule is finalized. So we do have some time. Clearly, this rule will not be in effect for some time, but that doesn't mean that folks don't need to start thinking about what they might do if such a rule was put into place.
Well, so what, if anything, should employers do now? A lot of our clients have a lot of non-compete agreements out there. What should they be doing?
Right. Well, I think it's important and valuable for every company that utilizes non-competes to really take a close look at how and why they're using them and who they apply to. Check your employee handbooks and check your departure processes for exiting employees and see how you handle that. I think companies need to start thinking about whether some of the alternatives to non-competes might be equally effective or even better. The current proposal on non-competes would not bar trade secret limitations and employee confidentiality agreements, provided that they're used in appropriate circumstances. So I think a lot of employers want to and should be thinking about, should we pivot to the use of trade secret protections and confidentiality clauses as opposed to these sort of blunt instrument non-compete provisions that lots of folks, lots of employers have used just because they were simple and easy to administer. I think we're going to see a lot of sophisticated employers really honing in on the benefits of the use of trade secret protections in the right circumstances.
Excellent. Well, Jim, thank you so much for sharing your insight on this. This actually concludes our presentation on navigating the FTC's proposed rule on non-competes. We thank you very much for your time today. If you have any follow-up questions, feel free to reach out to Jim or me about this. And as Jim mentioned, the comment period is still open on the proposed rules, so feel free to submit your comments to the FTC. We'd be happy to point you in the direction of their website. So we hope you have a great day and thank you for attending.